Today, this is the big issue. Kilmar Abrego Garcia. Anybody who doesn't know or has maybe tuned out for a little bit because so much has been going on, I don't blame you on that latter one, because that is kind of the goal right now. They're trying to make it so it's so difficult to follow everything, and then they're just outright lying about stuff that the Supreme Court says, because they know everyday people who are going to their jobs, who have stuff to do, they just don't have time to read up on that stuff. So that's why I'm here. That's why I'm helping out, and I'm more than happy to give you guys the rundown and give you guys the update on how things have been going. As everybody gets in, we're going to get started here. I think we're going to do another LegalEagle review. The big thing about him is he just hits the nail on the head. He's done a video after this, and I always like giving a couple days. I don't like reacting to stuff right away. I feel like I'm taking away from their traffic or something like that. But I just feel like he does a good rundown, and it'll be good to do on a live, and it'll maybe reach a different audience who doesn't usually get it. So let's get right in to the rundown of Kilmar Abrego Garcia.
He's never been tried or convicted in a criminal court. No immigration court has ever ordered his removal. But on March 12th, ICE agents pulled him over, threatened to take away his son, and sent him to rot in El Salvador's notorious torture prison. The administration has admitted that his removal and rendition was an administrative error. The Supreme Court ordered Trump to facilitate his release, but President Trump and El Salvador have announced that they will not release Mr. Abrego Garcia.
How can I return him to the United States? Like I smuggled him?
This decision arguably defies a Supreme Court order, openly flouts district court orders, and tramples on the fundamental right to due process. Now, we've talked a lot about due process lately because there's been a lot to talk about on the subject, but also because due process is an essential component of a fair and functioning country. Due process rights protect us all against arbitrary abusive actions by the government. They ensure that everyone has the right to counsel, the right to a fair hearing, and the right to hear evidence against them, and the right to rebut that evidence. These substantive rights and processes help to ensure that innocent people aren't punished based on weak or non-existent evidence, that they aren't sent to prison because they don't have the legal knowledge to defend themselves without the help of an attorney, and that they understand.
Yeah, one of the best ones I heard about this, there are like a couple channels now, people are starting to argue, like the Trump supporters are starting to get a little bit loud. They're tired of hearing all these liberals, keep saying that we're doing all this bad stuff, and I should be able to go and argue my point. If we're right, we should be able to argue. So I've seen some Instagram reels and stuff like that where people are going through, and the best question is, so people will say that the defense that they have for the administration is, well, he's an MS-13 gang member. And the response should be, this should be your question back to these people right away. Okay, if we're taking that at face value and that's enough to get you deported without due process, then I, sir, accuse you, or whoever you are, of being a member of whatever gang, MS-13, Tren de Aragua, whatever it might be, whatever special designation that they're using, I accuse you of doing it. Oh, that's ridiculous. I'm not a member of that. Okay, you don't get a chance to prove that in court. You're already on the plane and you're already shipped. What now? Oh, that would never happen. You're a fucking idiot. That's why you have due process. You need a chance to prove your case in court. You are innocent until proven guilty. You have an assumed innocence, not this assumed guilt. Like, this is a totally backwards way. This is not how we do things in America. It wasn't how we did them before.
And what they are being accused of, and have an opportunity to present evidence and defenses. But the ramifications of what has happened to Kilmar Abrego Garcia should disturb every American, because if the administration gets its way, then anyone, including the people watching this video, yes, you, the person watching this video right now, could be renditioned to a foreign country as long as the government renditions you fast enough before the courts can kick in.
That's why we really like the LegalEagle reviews. We go back to these, and I like to pay the respect. Like I said, we try and wait about 48 hours to make sure that we aren't taken away from his traffic, and then I try and make sure I'm breaking and adding the things that I do, because I don't watch these beforehand. He does a really good job, and if he ever said anything that I disagreed with or that was way off base, I would absolutely say something. But you see right there, he's getting to the heart of the matter. It could be any one of us. So if you're arguing with somebody, you can ask them that question directly. How could this not be you? Explain to me what process you would use to prove that you weren't guilty of any alleged thing. Because that's the thing. There's no charges being brought. They don't even have charges. Like, you can't even dispute. What do you dispute? There's no, they're just taking you.
Mr. Abrego Garcia grew up in Los Nogales, El Salvador, where his family ran a pupuseria out of their home. And according to findings by an immigration court judge, David Jones, for years the Barrio 18 gang extorted and threatened the family. The gang regularly threatened to kill him and his brother and rape his sisters if his parents did not pay regular bribes. One day, when Mr. Abrego Garcia was around 12 years old, Barrio 18 gang members arrived at the home and told his mother that they were going to take Kilmar and force him to join the gang because his family had not paid the bribe money. Kilmar's father managed to save his son by giving the gang members all the money that they demanded, but the gang continued to stalk Kilmar whenever he left his home.
See, these are the things. I haven't gone through Kilmar's cases or anything like that. I've heard about the stuff that we have, the information that we have. I believe, I don't know specifically because we haven't talked about where this case is coming from, but I believe this is the 2019 case where the last time it was ruled that I think they stayed his motion to. We'll get more into it here where you go see it, but this is why I like going in, watching Legal Eagles. He gets right to it. And if we need to, we can always pour through these ourselves. But I love that somebody has taken the time to pull these. And then if we ever need to, we can go through and we read the full document like we did last time. So we read the Supreme Court case, the dissenting opinions from that one to see the issues with it. And then you see the 9-0 ruling. But the administration ignored, they went even further than I thought. They ignored the 9-0 ruling and they didn't care about that anyway. So I thought it would be something. You have the dissenting opinions and you have the dangers of what could happen even with this 9-0 ruling. And then they had the administration had the audacity to just blow right past it. Who cares about a 9-0 ruling? We just can lie about that in the Oval, and it's just no big deal.
His father, a former police officer, paid them off, but the threats persisted. The police could not help. The gang infiltrated the police. After repeated moves and increasing danger, Kilmar's family sent him to live with his U.S. citizen brother in Maryland. In Maryland, Kilmar apparently lived quietly, working construction and raising a family with his partner Jennifer, a U.S. citizen. In 2019, while seeking day labor at a Home Depot, he was arrested with 3 other men despite no charges or no...
So it is the 2019 case. So on March 28th, 2019, plaintiff Abrego Garcia went to a Home Depot in Hyattsville, Maryland to solicit employment. When he arrived, he joined 3 other young men who were also at Home Depot soliciting employment, two of whom he recognized from prior occasions. Gosh, if we go to the Ramallah report and I'm reading like this is going to be bad. From prior occasions at the Home Depot, though he had never interacted with them in any other context. The young men proceeded to chat to pass the time.
Gang ties. The only evidence offered by ICE was a bull's hat and a claim by a confidential informant linking him to a New York-based gang he had no ties to.
And that was the thing. I remember it being, I heard this in passing, but I hadn't read it. We can see it here. The information that they have in support thereof, ICE offered a gang field interview sheet, GFIS, generated by PGPD, so a police department, so can't trust that. The GFIS explained that the only reason to believe plaintiff Abrego Garcia was a gang member was that he was wearing a Chicago Bulls hat and hoodie, and that a confidential informant advised that he was an active member of MS-13 with the Westerns clique.
Local police had no record of any charges against him. Mr. Abrego Garcia applied for release on bond, and ICE opposed his release, claiming that he was a dangerous gang member based only on the Chicago Bulls hat and hoodie, as well as the...
Damn, is this how ICE has been? That's the other thing, too. I love getting into these cases, because is that how ICE has been dealing with people up to this point? Where it's like, oh, yeah, it's just people doing their job. It's just, law enforcement. It's just these people, honest enough, just doing a job. Nah, like it's written down that you just have suspicion, like you just have random. And remember, a lot of the times that you get these snitches and stuff like that, people will say anything to get out of charges, and cops will cut deals with criminals that they like or for whatever reason. It's a broken system, a big old club, and you're not fucking part of it. These people feel like they are above the law because they are allowed to administer the law in some way. It's fucking disgusting. And I personally have always thought it to be a problem. The ideas of freedom and justice that we have in America fly directly in the face of the current state of our police system. This gang organization that it has become, where they protect their own and then violently deal with anybody who opposes them. Yeah, this shit ain't gonna fly.
Infusing confidential informant testimony. And on the basis of ICE's claims, out of an abundance of caution, the immigration court denied Mr. Abrego Garcia's request for release on bond. So he continued to remain in the detention center. From there, he filed an application for asylum with an application for withholding of removal. Now, as stated by the UN, asylum...
So I imagine this is just one of those things where, yeah, you got denied, so you just try your next thing. And then the people that oppose this, the people that are going to say, oh, how can he apply for asylum? He only did this because he was in there. you understand that you would support your side doing this, just taking every legal avenue. You're allowed to steal an election as long as it's every legal avenue. It's a novel theory. Oh, you're allowed to send fake slates of electors. They have all this nuance for their side, but then you just ask them to extend it, and the maggot simply can't.
Asylum is a form of protection which allows an individual to remain in the United States instead of being removed, deported to a country where he or she fears persecution or harm. And seeking asylum is legal immigration. Under U.S. law, people who flee their countries because they fear persecution can apply for asylum. They're called asylees. And relevant to Mr. Abrego Garcia's claim of asylum, at the conclusion of the 2-day hearing, the immigration judge found that Mr. Abrego Garcia had, quote, provided credible responses to the questions asked. His testimony was internally consistent, externally consistent with his asylum application, and other documents, and appeared free of embellishment. Judge Jones found that Mr. Abrego Garcia also provided, quote, substantial documentation buttressing his claims. However, the judge denied his asylum petition on a technicality. He had missed the 1-year deadline. Instead, he was granted a withholding of removal under INA Section 241B.
Got you. So because he had missed the window, they can't grant him the official asylum, but this is an on the books,
which is a protection against deportation to El Salvador due to a clear risk of persecution by Barrio 18. Now, withholding of removal.
So the withholding of the removal isn't technically ruling in his favor, but gets him the ability to stay.
Offers less protection than asylum.
Yeah.
Unlike asylum, it doesn't grant legal status or a path to citizenship. It only bars deportation to a specific country. It's granted if the person proves a clear probability of persecution based on race.
So the only thing it should guarantee is he doesn't have to go back to the one country that they sent him
religion,
to.
nationality, social group, or political opinion, which is actually a higher standard than asylum. Judge Jones found that Mr. Abrego Garcia had met this standard. He had credibly shown that his life had been threatened by Barrio 18 on multiple occasions. And at the conclusion of the hearing, Mr. Abrego Garcia was released to return to his family in Maryland. Now, neither ICE nor local law enforcement ever made further claims about his membership in any gang. And since then, Kilmar has lived peacefully, supporting his family and caring for his disabled son. He had complied with immigration check-ins and had no legal issues until March 12th of this year, when he was pulled over while driving with his son. Now, on March 12, 2025, after finishing a shift as a sheet metal worker apprentice in Baltimore, Mr. Abrego Garcia picked up his son from his grandmother's home. That's when ICE officers pulled him over. They told him his status had changed and threatened to call Child Protective Services unless his partner, Jennifer Vasquez-Sura, arrived within 10 minutes to retrieve their son. Mr. Abrego Garcia was shuffled around to several locations over the next few
Like, how awful is that? Oh my gosh, can you imagine?
days. His wife Jennifer spent days trying to locate him, discovering that he'd been transferred between multiple facilities across the country. She repeatedly informed the government that Kilmar had been granted a withholding of removal, but her objections were ignored. So Miss Vasquez-Sura had no idea where her husband was until her brother-in-law sent a
And that's the other thing, it's intentional. Moving him around this way is intentional.
news report about the people who had been sent to El Salvador's torture prison by President Trump. That article contained a picture of a man who had a tattoo and scars that matched Mr. Abrego Garcia's. More news media photos confirmed that he was indeed being held in El Salvador's terrorism confinement center, despite the fact that he had a valid withholding of removal, and despite the fact that he was never given a hearing or was ever formally charged with any wrongdoing. So now, with that knowledge, Ms. Vasquez-Sura filed a suit on behalf of her husband, herself, and their 5-year-old son in the United States District Court for the District of Maryland. Now, in their complaint, the plaintiffs allege that by sending Mr. Abrego Garcia to the Terrorism Confinement Center, or CCOT, without any kind of hearing, the Trump administration had violated the INA provisions governing withholding of removal orders, the Administrative Procedure Act's prohibition against arbitrary and capricious government actions, and the Fifth Amendment's guarantee of due process.
Which it has, absolutely. It's such a good, clear-cut reason for the
Mr. Abrego
case.
Garcia also filed a habeas corpus petition arguing that the Salvadoran government was detaining him at the express direction of the Trump administration. And if you've been following along with all the Supreme Court antics involving the JGG plaintiffs previously in Judge Boasberg's courtroom, then you know that a habeas petition was an incredibly important thing for them to file. We'll talk more about that in a second. Now, the Trump administration is...
The habeas one is, I think, what split. There was a habeas decision that went 9-0, and then that they should have it, but then there was a dissenting per curiam opinion. Hopefully he'll go through it here, and this is why I feel like it's pretty good. He does a really good job of getting
El Salvador
getting it all in a timeline for us. But the important thing is to make sure that you have this information somehow, some way, get it into a manageable form that you can get, and make sure that you can trust the reliability. Go back and read what you can. So for me, It's going through, and then the things mentioned here, making sure we read them as well.
$1 billion to house 300 men for a year. Trump and Salvadoran leader Nayib Bukele, the self-proclaimed coolest dictator.
Or another good thing is the things that you have read already. If you can find somebody that goes through and it does confirm it, somebody else has read the same thing or has done the same similar research and maybe spent more time, especially someone like this, they have the resources to do quite a bit more research, or they have someone that they can pay to do the same amount of research. You can, it's not the worst thing in the world to lean on people that you can prove to be credible. You just have to prove them to be credible. I'm not saying go and trust everybody every time, but there are some people that you can vet quite a bit and then get to a point where you can trust them. But always check up as well. Make sure you're not just blindly following anything.
Have both publicly bragged about this arrangement. In a March 16th post on Twitter, Bukele acknowledged their financial agreement, stating, quote, "Today, the first 238 members of the Venezuelan criminal organization, Tren de Aragua, arrived in our country. They were immediately transferred to CICOT, the Terrorism Confinement Center, for a period of 1 year, renewable. The United States will pay a very low fee for them, but a high one for us." Bukele also bragged about how the prisoners in CICOT are being used as slave labor, stating, quote, "Over time, these actions, combined with the production already being generated by more than 40,000 inmates engaged in various workshops and labor under the Zero Idleness program, will help make our prison system self-sustainable."
This is how they're calling slavery now. The Zero Idleness
The plaintiffs
program.
also allege that the Trump administration knows that the men in CICOT are being subjected to torture. Their complaint includes a harrowing list of details about the conditions in CICOT based on credible news reports and independent investigations, including 153 inmate deaths in a 1-year period, many of which can be attributed to torture, beatings, strangulation, and lack of medical attention. Now,
Jeez Louise.
autopsies have revealed patterns of cuts, hematomas, sharp object wounds, and signs of strangulation. Survivors of the prison report being subjected to electrocution and untreated infections. The prison has no windows, fans, or air conditioning despite hot, humid, tropical conditions. And prisoners are housed in overcrowded cells and are denied access to reading materials, familial visits, exercise, and outdoor time. Given the appalling conditions that he's being held in, Mr. Abrego Garcia and his family implored the court to grant a temporary restraining order, or TRO. Plaintiffs noted that if the Trump administration had wanted to remove Kilmar legally, it had several lawful.
And as far as I understand, this is like exactly what TROs are for. If you're going to face some real damage between now and then, that the TRO is supposed to be able to. And this is why I think you're not allowed to challenge in this way or appeal in this way. And Trump is just jumping past these things. There are certain things that you can and can't appeal, and there's certain relief that you can get. And the executive is just stomping all over that.
Options. It could have appealed the original grant of withholding of removal, sought to reopen the proceedings under the INA, or even deported him to any country other than El Salvador. The only country his withholding protected him from was El Salvador. Instead, the administration pursued an entirely different path. And maybe Mr. Garcia is a member of MS-13. Maybe he's Space Hitler. But we don't know because the administration never tried to prove it. Unlike the JGG plaintiffs.
It's telling that they didn't even try to prove it. It's telling that they never try to argue the 2020 election one. They just asked for immunity. Trump just asked for immunity on that one. Oh, it's legal to do what I did, right? Because I had to.
It isn't relying on the Alien Enemies Act in Kilmar's case. That executive order applies only to Venezuelan nationals. Rather, the sole justification the administration has offered is a vague, unsubstantiated claim that Mr. Abrego Garcia was affiliated with MS-13.
And by the way, we should find the Sebastian Gorka clip. So now they can just say, oh yeah, you're affiliated with this thing because we have some random person that's not named that's saying so. Remember this. Now Sebastian Gorka, one of the people working with the Trump admin, is saying things like, oh, well, if you support Mr. Abrego Garcia, you are one of the people that's supporting MS-13. You are supporting these gangs. So you are aiding and abetting enemies of the state. That's what these people are saying now. Those are the connections that are being made. If you ever wonder how we get there or how slippery the slope can be, this is how slippery.
The State Department had previously designated MS-13 as a major transnational criminal organization designated terrorist group in February of 2025. Now, the Trump administration has presented zero evidence that Mr. Abrego Garcia is a member of MS-13 or any criminal organization. Mr. Abrego Garcia has never been found guilty of any crime or even charged with any crime. But in response to the plaintiff's motion for TRO, the Trump administration actually admitted that, quote, although ICE was aware of his protection from removal to El Salvador, Abrego Garcia was removed to El Salvador because of an administrative error.
That admission alone is just insane. It's insane that we have it. It's a sign of the incompetence. You know, one of the good things, I know there's not many good things, but one of the good things about Trump is just how stupid he and his people around him are. The people he continues, smart people he had around him for the first term all jumped ship. They all understood that this was way beyond anything that they could deal with, so they got out of there. So now you have just stupid people, sycophants, or truly evil people. Stephen Miller is a truly evil person. When Hitler took over, remember, Hitler wasn't the one that came up with the final solution. There were other solutions first. Let's deport him, let's get him out, let's do what we can. But then someone, I can't even remember who actually came up, and I'm not going to look it up right now, but it was one of the members. If we want to do a deep dive into World War II, I would love to. And it may be the time for it. The rise of fascism and seeing how it does. In more than entertainment, it might be good for research purposes, so I may do it. But that is the big thing. It wasn't the main guy who came up with it. There are evil people waiting in the wings that are looking for an opportunity to be useful. And if they can be the creative voice, even if that creative thing is horrendous, they'll step forward and do it. That's your Stephen Miller. Calling my shot right now. Calling his shot.
The government's declaration by Robert Sina, acting field office director for enforcement and removal operations at ICE, affirmed this, stating, quote, through administrative error, Abrego Garcia was removed from the United States to El Salvador. This was an oversight. Now, despite this admission, the administration went on to claim that the Maryland court cannot offer was removed from the United States.
And the removal was carried out in good faith based on the existence of a final order of removal and Abrego Garcia's purported membership in MS-13. I declare under penalty of perjury that the foregoing is true and correct.
To El Salvador, this was an oversight.
Just reading the extra
Despite this admission, the administration went on to claim that the Maryland court cannot offer Mr. Abrego Garcia.
We might have to just go and read that 2019 case. If it keeps coming up or if it keeps hanging in limbo this way, there's been updates, and we know that he's at least alive now and safe. The senator, I think it was Senator Holland, so much going on. I think it was Holland went and talked to him, so we know. But it's still going to be interesting to follow where this goes, because how hard, similar to tariffs, the admin has come out against going back on these things. No, we're going to stick a hard line on these. No, we're going to stick a hard line on China. Okay, that's cool. The things that you have set yourself as your goals are wild.
The administration argued that Mr. Abrego Garcia's case must be brought as a habeas corpus claim, which can only be heard by a court with jurisdiction.
This shit gets into the Supreme Court
over the detainee's custodian. And they argue that since he was already deported to El Salvador when the suit was filed, no U.S. court has jurisdiction.
Can't do anything.
The Trump administration also asserted that the plaintiffs lack standing because the court can't compel El Salvador to act. Now, Maryland Federal District Judge Paula Zenas was understandably skeptical of all the administration's claims. She rejected the administration's evidence-less claims that Mr. Abrego Garcia is an MS-13 gang member, stating, quote, when someone is accused of membership in such a violent and predatory organization, it comes in the form of an indictment, complaint, or criminal proceeding that has a robust process. And at the hearing, she said, quote, all this points to a functional control, and that if the United States as a contracted party can have the functional control of the placement, the wrongful placement, they certainly have the functional control of the return. So on April 4th, the judge granted a preliminary injunction ordering the Trump administration to, quote,
such a good point. That is how I try to make that point myself. These people are the first ones to claim victim anytime a charge gets brought against them, that it's some persecution or something like that. But then they have the ability. They have the ability to bring the charges. They have the ability to bring evidence right now, and they choose not to. They choose to go around these systems and not charge people with crimes, not have indictments. Look at the Elon Musk, waste, fraud, and abuse. What fraud, what criminal fraud has happened? If you had anybody in the government that was committing fraud, if you had anything that was truly fraudulent, you would have dragged those people out into the streets and you would have had them publicly tried. It would have been a huge thing if they could have done these things. If there was any evidence that any of this bullshit that they claim is going on, even the maggots, you have to understand, they would do it if they could, right? They'd bring charges on every single one of these. If you found out that, this money was supposed to be going here, but they fraudulently took $5 million that was supposed to go to taxpayers here, and they put it towards Planned Parenthood, or they put it towards some liberal ideology or something we don't like. Fraudulently, they broke the law in order to do so. You don't think if they would have found that would have instantly made the news? You don't think that would have Fox News, Newsmax, OAN, you don't think these would have been blowing up with we found the deep state. We found the evil people underneath, but they don't have anything. Just like this judge said, the way that these things are done, you bring indictments, you bring criminal charges. These people haven't even been charged. No day in court to argue whether or not you're the MS-13 gang member. The accusation is enough. The McCarthyism, oh, they're a communist, it's enough now. It's insane, the Rubicon that we've crossed.
Facilitate and effectuate the return of plaintiff Kilmar Armando Abrego Garcia to the United States by no later than 11:59 p.m. on Monday, April 7, 2025. White House Deputy Chief of Staff Stephen Miller responded to the news about Judge Zenas' ruling on Twitter saying, quote, Marxist judge now thinks she's president of El Salvador.
Words just don't mean anything. You just throw everything out.
Bukele posted on Twitter with his usual level of gravitas and maturity, and White House Press Secretary Caroline Leavitt issued a statement that, quote, we suggest the judge contact President Bukele because we are unaware of the judge having jurisdiction or authority over the country of El Salvador. And so the administration immediately and predictably appealed Judge Zenas' order, begging the Court of Appeals of the Fourth Circuit to please allow them to send people to the gulag immediately with no questions asked. And predictably, all three judges in the Court of Appeals were unconvinced by the administration's arguments. Judge Thacker, an Obama appointee, wrote the opinion of the court saying that, quote, the United States government has no legal authority to snatch a person who is lawfully present in the United States off the street and remove him from the country without due process.
What a good quote.
The government's
This is a
contention
banger.
otherwise, and its argument that the federal courts are powerless to intervene, are unconscionable. She also noted the government, quote, screwed up and must, quote, clean up the mess it has made. And so the Trump administration asked the Supreme Court to vacate the district court's ruling. And on April 7th, the Supreme Court granted a temporary stay, pausing Mr. Abrego Garcia's return while it considered whether Judge Zenas' order should be vacated. The court allowed the district court's temporary restraining order to expire, which is how the Trump administration got out of the whole JGG debacle where Judge Boasberg had ordered them to turn the planes around, which is not a great pattern. And finally, on April 10th, the Supreme Court unanimously ruled against the Trump administration's motion to vacate Judge Zenas' order.
This is the big one. 9-0, the Supreme Court said, go fuck yourself, admin. And they said, well, what are you going to do about it?
And this decision by the Supreme Court is a complete mixed bags. But all 9 justices, including 6 Republican appointees, 3 of whom were appointed by Trump, found that the lower court's order to facilitate the return of Mr. Abrego Garcia should stand. The justices found, though, that the portion of the order that commanded the Trump administration to actually effectuate Mr. Abrego Garcia's return may have exceeded Judge Zenas' authority and would need to be clarified by Judge Zenas with, quote, due regard for the deference owed to the executive branch in the conduct of foreign affairs. Now, the Supreme Court indicated that Judge Zenas' order that the government effectuate Mr. Abrego Garcia's return might exceed judicial authority. The court didn't spell out a specific reason for that, but a typical reading of the term effectuate would indicate that it would require the government to ensure a particular outcome, as opposed to requiring the government to simply take steps to facilitate it.
I hate these fucking games that we're playing now. And meanwhile, people's real lives are in the balance.
And there are reasonable separation of powers issues here. Ordering the administration to guarantee Mr. Abrego Garcia's return could mean effectively ordering some kind of military action if El Salvador outright refuses to return him. And everyone agrees that a judge can't do that. Now, facilitate is a much looser term, which has led to a series of disputes in this case since the Supreme Court's holding. The Trump administration is reading the order to facilitate Mr. Abrego Garcia's release from the Salvador
As we don't have to do shit.
in custody in the most minimal fashion possible, claiming that when Judge Zenas and the Supreme Court ordered this, all they really meant was removing any domestic obstacles that would otherwise impede the alien's ability to return. And the Supreme Court also instructed the government to, quote, be prepared to share what it can concerning the steps it has taken and the prospect of further steps. But Justices Sotomayor, Kagan, and Jackson took the Trump administration to task for its illegal action, stating that, quote, to this day, the government has cited no basis in law for Abrego Garcia's warrantless arrest, his removal to El Salvador, or his confinement in a Salvadoran prison, nor could it.
And that's the big thing. That's the strategy. You don't even argue anymore. There's no point in arguing the positive on their side because there is no argument. You just say you're right. And then if, oh, well, the Supreme Court ruled this way. No, they didn't. They ruled the exact opposite. They ruled for us. This is the shamelessness that you have to deal with. And it's genuinely hard to deal with. We have not figured out a way to combat it, at least in people's minds. Because to people who are already on the outside, that sentence makes no fucking sense. But apparently to people who are on the inside of the cult, it checks out enough and then they stop asking questions.
And the 3 justices raised alarms about the Trump administration's due process violations, warning that, quote, the government's argument, moreover, implies that it could deport and incarcerate any person, including U.S. citizens, without legal consequence so long as it does so before a court can intervene.
And the courts, he said it in an earlier video, but I feel like it needs to be reiterated. The courts have to take their time. So that's a very dangerous precedent to set. If the court can't, get a ruling in time and get you out, you won't be saved. It happened just recently. Somebody was mistakenly picked up and then released in time because they were able to get it through. But courts are supposed to take their time just so you don't have the appeals or the issues that you had. Not saying that Judge Ginnis or whatever rushed her opinion, but if you do rush opinions or if you do have these speed, irregularities, you may run into some issues down the line and get appeals and stuff like that. And it's even more barriers to what is right. It's crazy that it's going to happen this way, that it's going to be the judges and whether they can save you or not, and if they have the authority to bring it. Because right now it just seems like the Supreme Court can do nothing. No actual teeth.
Concurring justices admonish the administration to comply with due process of law and provide Mr. Abrego-Garcia with all the process he should have been entitled to, including notice and a hearing. But the Supreme Court's ruling also opened the door for Trump to argue that he has no power to actually effectuate Mr. Abrego-Garcia's release. Now, unless you're the U.S. government, if you're kidnapping immigrants, you're going to want a good lawyer. But if you want a great lawyer, let my law firm, the Eagle Team, help. If you've gotten in a car crash, suffered data breach, especially with data breach letters saying that your information might have been leaked, or dealing with a workers' comp or social security issue,
quite a bit of
we can
watching
represent you
channel.
or help find you the right attorney.
If you ever do need a
By
lawyer,
the way, we don't get paid unless you do, so there's
it.
nothing up front. So just click on the link in the description or call the phone number on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle Team. On remand, Judge Zinnes quickly amended her order to remove the word effectuate. She commanded the Trump administration to provide the basic details about Mr. Abrego-Garcia's whereabouts and status, as well as the steps that the government is taking to recover him, in keeping with the Supreme Court's order that the government, quote, should be prepared to share what it can concerning the steps it has taken and the prospect of further steps. And she gave the administration until 9:30 a.m. the following morning to provide her the relevant details.
Which they
After
did.
they failed to meet this deadline, Judge Zinnes granted the Trump administration an extension until 11:30 a.m. that day, a deadline that they once again failed to meet.
Yep.
But instead of providing the required answers, the Trump administration filed a motion whining about the impossible deadline and claiming that they simply could not share any of the requested information with the court at this time. But Judge Zinnes wasn't having it and ordered the Trump administration to respond daily with the following information. Quote, the current physical location and custodial status of Abrego-Garcia, what steps, if any, defendants have taken to facilitate his immediate return to the United States, what additional steps the defendants will take and when to facilitate his return. She scheduled a follow-up hearing for Tuesday, April 15th. Now, the government's first status update was a 3-paragraph insult, and the only actual information contained within it was that Mr. Abrego-Garcia was alive and imprisoned at CCOT. One wonky thing is that when you file a status report like this, it must be backed up by a declaration, which is a written statement that's made under oath. This particular statement is about as wishy-washy as you can get. It was filed by a member of the Department of State, and it says, quote, it is my understanding based on official reporting from our embassy in San Salvador that Abrego-Garcia is currently being held in the Terrorism Confinement Center in El Salvador. He's alive and secure in that facility. He is detained pursuant to the Sovereign Domestic Authority of El Salvador. Now, to me, as a litigator, given the several layers of intermediation before that person actually signed their name to something under oath, that sounds like someone who doesn't want to be held in contempt for actually making factual statements that may or may not be true. But notwithstanding, the next status update was even less substantive. The government
Yeah, just the fact that you missed all the deadlines and then you can do that. Is this what you can do to a court now? Is this how we can respond to court? Is this how every citizen can respond to a court?
representative simply stated, quote, it is my understanding that the defendants have no updates for the court beyond what was provided yesterday. Again, this means the administration is simply deciding not to answer the court's questions, or that is simply not taking steps to facilitate Abrego-Garcia's return. Now, in light of this non-compliance, plaintiffs filed a motion with the court requesting additional relief, including expedited discovery against the Trump administration and a potential contempt finding against the administration. The Trump administration responded, claiming that when the Supreme Court and Judge Zinnes directed them to facilitate Mr. Abrego-Garcia's return, all that really meant was that they should, quote, take all available steps to remove any domestic obstacles that would otherwise impede the alien's ability to return here. But as luck would have it, because we live in the worst timeline and everything is kayfabe, on April 14th, Trump and Bukele actually had a televised meeting.
This one was awful. This is just word games with a man's
At the
life,
White House,
and it's so disgusting.
Where they mocked the court system. On the same day, Stephen Miller claimed that Abrego-Garcia was not sent to El Salvador by mistake.
He was not mistakenly sent to El Salvador.
Okay, so do you still
He's
believe
an illegal
he is a
alien
member of
from
MS?
El Salvador?
But as we've talked about, it's important to note that the administration has admitted their mistake to the court at least 3 times. First by Robert Sina, acting field office director for enforcement and removal operations at ICE, and twice in briefs filed by the Solicitor General, D. John Sauer. Attorney General Pam Bondi has also falsely claimed that 2 courts ruled that Mr. Abrego Garcia was a member of MS-13.
He was illegally in our country. He had been illegally in our country. And in 2019, 2 courts, an immigration court and an appellate immigration court, ruled that he was a member of MS-13.
So you can just lie. This is defamation. Like, this is the person who should know. So whatever gross negligence, whatever threshold you need to meet, this is this person's fucking job. This is the attorney general. This is the person. No one would have more access to these documents or the factual reality of the situation. Why are you allowed to fucking lie like this? You should just be able to sue this person for lying about you. Libel, defamation, all the shit. What is going on? Nothing could be more clear.
And he was illegally in our country.
And Bukele even labeled him a terrorist, but no court has ever concluded that Mr. Abrego Garcia is a terrorist or a member of MS-13. And as we talked about, a court issued the withholding of removal the last time Abrego Garcia had been in court because he had, in fact, been a victim of gangs in El Salvador. But according to the Attorney General, what the Supreme Court meant when they said that the government has to facilitate Mr. Abrego Garcia's return is just that if President Bukele decides to return him, the United States has to, quote, provide a plane.
This is international matter.
So it's just up to the whims of this person. As long as you get it to this dictator, they can talk behind closed doors and there won't be evidence. This is the problem with the second Trump term. The first Trump term, he didn't have allies like this. He didn't have people that could help him this way. He didn't know who would be these people. Now he's had the time. He's had the ability to make these arrangements. And so now we'll see, even though they are so incompetent, the American voter showed more incompetence by allowing him back in.
Foreign affairs.
Myself included.
If they wanted
I
to
could have done more.
him, we would facilitate it, meaning provide a plane.
Now, in the same meeting, President Bukele confirmed that he has no intention of returning Mr. Abrego Garcia to the United States or releasing him within El Salvador.
How can I return him to the United States? Like, I smuggle him into the United States, or what do I do? Of course, I'm not going to do it.
And to add injury to the insult to the injury, Trump says he really does want to send American citizens to the terrorism prison in El Salvador.
I said, homegrowns are next. The homegrowns. You got to build about 5 more places.
Yeah, that's fair.
All right.
So we are not in a good spot. In this case, the government has told 3 courts.
That's putting it mildly. Not in a good spot. The president of the United States is talking about sending American citizens to a foreign prison.
That Kilmar Abrego Garcia was wrongfully removed, and a unanimous Supreme Court said that the government must facilitate his release. And yet, Trump is now openly flouting the court's order in order to keep an innocent man imprisoned. The ramifications here could not be more dire. Trump asserted that he has a right to do this to American citizens, telling Bukele that he should build 5 more prison camps that Trump will fill with undesirables, which is plainly at odds with the claim that they have no power to get Mr. Abrego Garcia back, which was foreshadowed in Justice Sotomayor's dissenting opinion in JGG versus Trump, where she said, quote, "What if the government later determines that it sent one of the detainees to CCOT in error, or a court eventually decides that the president lacked authority under the Alien Enemies Act to declare that Tren de Aragua is perpetrating or attempting an invasion against the territory of the United States? The government takes the position that even when it makes a mistake, it cannot retrieve individuals from the Salvadoran
not our problem.
prisons
He's
to
already
which
in El
he was sent
Salvador.
them. The implication of the government's position is that not only non-citizens, but also United States citizens could be taken off the streets, forced onto planes, and confined to foreign prisons with no opportunity for redress if judicial review is denied unlawfully before removal. At base, the Supreme Court unanimously affirmed the district court's order, quote, properly requires the government to facilitate Abrego Garcia's release from custody in El Salvador and to ensure that his case is...
The order properly requires the government to facilitate Abrego Garcia's release from custody in El Salvador and to ensure that his case is handled as it would have been had he not been improperly sent to El Salvador. Like, this is the unambiguous reading of it.
Is handled as it would have been had he not been improperly sent to El Salvador. And back at the district court, the government's final status report included no new information about Mr. Abrego Garcia's status. The government submitted a declaration by DHS Acting General Counsel Joseph Mazzara, who said that the U.S. was prepared to facilitate his entry into the U.S. by not allowing him to re-enter the United States. If Mr. Abrego Garcia presents to a port of entry, the United States will, quote, remove him to a third country or terminate his withholding of removal because of his membership in MS-13. Again, no mention of the regular immigration process. The Supreme Court has yet to say what facilitate means in this context, but the government is stating for the record that it believes it can send Mr. Abrego Garcia somewhere without any due process, and that's within the meaning of the word facilitate. Now, you might be wondering whether the government can get away with that without being held in contempt of court, and so am I.
That's the tough part, is these are the experts and they don't know. This is how I felt for a long time, is everybody's talking about it like, oh, there will be a stop. I feel like everybody, even now, still thinks there's going to be a moment where they stop, and it's all the next domino. To me, it's just falling into the next one, and then where else is it going to fall? People have been seeing the dominoes fall one way, fall one way, fall one way, and we're seeing this chain of events. You're seeing it all come together, and then for some reason, you people think that this domino... Have you ever seen the experiment where you start with the smallest domino and you get to bigger and bigger ones? You don't need exactly the same same size of domino in order to get the domino effect. You can have larger and larger ones, so you can have a problem. Right now, you have a situation where you have one domino falling into another one, slightly bigger, slightly bigger, slightly bigger, and we're getting to these giant ones, but now you think that this one falling is going to make this one fall backwards. I don't understand what people are waiting for. You are the answer. That is it. We are the backstop. There is no criminal backstop. There is no, the Supreme Court is toothless. And then the one thing that we have left is the military. And Trump has already been purging them for loyalists. We've already seen the headlines. We did it. It happened in the background. And then now we've seen it. What happens when the order goes out that is absolutely unconstitutional for some amount of armed forces to be used against the United States citizenry? To be used against we the people? What happens then? Are we waiting for that moment? Do you guys think that that domino is going to fall the right way? Or are you relying on it? You may even think that, the members of the armed forces, they swear their oath to the Constitution and nothing else. It's not to a singular person. It's not to a person who holds a position of power. It is to the Constitution itself. And you may think that, but take a general population that you know, and how many Trump supporters are there in that population? How many people, how many loyalists are there? Do you really think you can rely on it? You may hope for it, but can you rely on this? I wouldn't. If I were you, I wouldn't rely on these people making the right decision, or this domino falling the opposite way that all the other dominoes have fallen. The Supreme Court is toothless right now. They are doing nothing. They are openly being defied, and you are seeing nothing in response. And here we have the real question. Here we have this lawyer, this expert saying, I don't know what's going to happen next. No one does. We are in uncharted waters, and there were clear ways to turn back. There were clear ways to get away from this waterfall. We could have gone towards the bank. We could have done anything else. We could have taken the other fork in the road. We have not. We are headed straight for it, and no one really knows how it's going to end up.
And in another contentious hearing before Judge Zenas on April 15th, the administration tried to argue that it had taken steps to fulfill the court's order to facilitate Mr. Abrego Garcia's return. The only evidence that the administration could offer, though, was the White House meeting with President Bukele the day before, which Judge Zenas found wholly insufficient. The government apparently showed up with a transcript of the meeting and asked for it to be considered evidence that the government was up against a foe that was impossible to defeat, Trump's pal Bukele. But Judge Zenas was not amused. She said she would not accept an out-of-court transcript of a YouTube video as evidence, and instead she would build a record using the rules of evidence. You know, the way we've done this for hundreds of years. And Mr. Abrego Garcia's counsel argued that the government has done nothing to facilitate his release.
Correct.
And asked for the deposition testimony of someone with authority to explain what actions the government has taken to comply with the Supreme Court's order. And in response to the administration's recalcitrance, Judge Zenas left open the possibility of a contempt finding and granted the plaintiff's request for expedited discovery. She indicated that she would be reviewing the government's discovery response to evaluate whether or not the administration is in compliance with her order. She told the government's
It's crazy. You just have to go through these steps and do it the right way, but then it just gets ignored in the end. It's just, you do everything the right way just for the other person to be like, oh, we don't care if you rule against
lawyers
us.
To cancel your vacations because she intended to do this on a very tight 2-week timeline. Now, that may not sound like a tight timeline to non-lawyers, but it is extremely fast for a case of this magnitude. The government's lawyer, Drew Ensign, stopped short of saying that the government would comply with the court's discovery orders. He indicated that he would probably object on the grounds that attorney-client privilege applied, and therefore someone like Mr. Mazzara could not be expected to testify. And Ensign repeatedly told the court that there was no factual issue here, and according to Anna Bauer, who was in the courtroom, Judge Zenas wasn't having it. She said, quote, "To what SCOTUS said was..."
I love the blue sky quote here. Love it, LegalEagle. Let's do it.
"Squarely in my power, and in my view, you have not fulfilled the mandate I've issued. Discovery will bear that out because the affidavits are insufficient." Then you may see the government try to appeal the court's discovery order. Ensign argued that Judge Zenas first needed to clarify her TRO, and the judge said no additional order was necessary. And as Bauer reported, paraphrasing, quote, "Not that difficult, the Supreme Court has spoken. Let's talk about what the Supreme Court has unequivocally deemed to be lawful. You made your arguments there, and this is now about the scope of..."
Well,
the remedy. And Judge Zennis's order following the hearing addressed the dispute over the meaning of the word facilitate. And she points out, quote, Merriam-Webster defines the term as to make it easier or less difficult to free from difficulty or impediment, whereas the Oxford English Dictionary defines facilitate as, quote, to assist a person, to enable or allow a person to do something, achieve a particular result. And the judge wrote that the defendants know what the word means and they failed to live up to any of these definitions. Quote,
exactly.
The defendants therefore remain obligated at a...
That's the crazy part. It's all a word game. It's all messing around. The facilitate, the effectuate, all that stuff is just games. All the while, it's how they do every case. Stall like crazy for everything, and then they're going to be the ones that, oh, this is a drawn-out thing. Have you noticed the recent response to questions, direct questions about denying Supreme Court orders? It's, oh, are you going to follow the Supreme Court order? And because they didn't follow it already, that's why you're being asked about it again. But their response to not following it and not answering the first question when you ask them about it the second time is, are you really asking about this again? That's why no one watches you. It's insane. You get to play on both sides of the fence all the time.
At a minimum, to take steps available to them toward aiding, assisting, or making easier Abrego Garcia's release from custody in El Salvador and resuming his status quo ante. But the record reflects that the defendants have done nothing at all.
Exactly. That's the thing. If you just didn't comply with court orders at all, what should happen to you?
Instead, the defendants obliquely suggest that facilitate is limited to taking all available steps to remove any domestic obstacles that would otherwise impede the alien's ability to return here. The fallacy in defendants' argument is twofold. First, in the immigration context, as it were, facilitating return of those wrongly deported can and has included more extensive government efforts endorsed in prior precedent in DHS publications. Thus, the court cannot credit that facilitating the ordered relief is as limited as defendants suggest. Second, and more fundamentally, defendants appear to have done nothing to aid in Abrego Garcia's release from custody and return to the United States to ensure that his case is handled as it would have been but for defendants' wrongful expulsion of him. Thus, defendants' attempt to skirt this issue by redefining facilitate runs contrary to law and logic.
I love that they're starting to put this in. I think we need more of this language. You need to, I know people aren't reading it or stuff like that, but when people do, the fact that this stuff, when I tell people who haven't heard about the crimes of this government, they are blown away and they have to double check it, even if they do trust me. They say things like, oh, that can't be true, or they can't, and they're not denying me. It is just stranger than fiction at this point. It runs contrary to law and logic. That is the judge saying that. We should start having these things listed. Understand that this stuff is not normal. I get it. It's a cult, so they just don't trust judges now, especially if judges disagree with them. But I really do think this is the ground we need to break. Understand that the people who are in the institutions are the ones sounding the alarms. Harvard University going out of their way to stand up to, would we even know if the other Ivy League schools all capitulated and didn't do anything about it? Would we only have Harvard? Because that's the only reason I know about it, is because Harvard is filing a lawsuit and going about fighting it. If all the other ones rolled over silently, what would we have? We'd have nothing.
And in a footnote, the judge references the other part of the Supreme Court's order, which says the district court must still give due regard for the deference owed to the executive branch. But in this instance, Judge Zennis says, quote, deference does not mean the court must ignore the defendant's repeated refusal to provide even the most basic information as to any steps they have taken to facilitate Abrego Garcia's release from custody in El Salvador and to ensure that his case is handled as it would have been had he not been improperly sent to El Salvador.
That's the thing. It's the deference can't be that the executive just can't be held to account by the court, because otherwise the whole system falls apart. We are literally seeing the arguments of whether or not the judicial, this went up to the Supreme Court and the Supreme Court said, hey, you got to respect the executive. And now we are like walking on eggshells, but this is the lower court saying like, we have to have something. There has to be, you have to be able to answer for something. Otherwise, what the fuck are we doing here?
But first things first, the plaintiffs will be allowed to conduct expedited discovery. And remember, we talked about the government declarations and not wanting to get subjected to contempt or discovery. Well, Judge Zennis is all over that. According to Anna Bauer, during the discussion about discovery, the judge said depositions will be completed by Wednesday.
Ooh, let's go ahead and follow this Anna Bauer, because it looks like they are doing some reporting that I would want to be a part of. I want to get in on this. If you aren't follow me, Blue Sky, stuff like that, make sure you go over Blue Sky, Twitter, all the good stuff. We're all over that. Boom, right back to it. Hopping back in, got a new
April
follow.
23rd, any impedient. The government lawyer Ensign said, quote, we understand court's position. The judge said, "So that means no impediments?" Ensign says, "We don't know at this time who will be deposed." Zennis says, "No, I'm saying the people who you've put forward as affiants." Ensign says, "I'm not prepared to put forward objections at this time. One of the affiants is acting general counsel." To which the judge says, "You should have considered privilege when you put them up as an affiant, but if you have privilege objections, you can get them to me." In other words, the government made lawyers sign factual sworn statements for which they may or may not have personal knowledge. And if you have someone sign a declaration under oath, the court is allowed to test the veracity of those statements, and you've arguably waived privilege. Unlike, for example, when a lawyer has signed a brief, which isn't under oath, though it does have its own obligations. So Judge Zennis is signaling that she is not going to put up with objections to that discovery.
No bullshit.
And in fact, in the judge's order, she specifically calls out the 4 government affiants and says that the plaintiffs can depose them. And those depositions must be completed by April 23rd. Fun. Now, after that contentious hearing, lawyer Heidi Feldman noticed that the court is following the exact same procedure that was used in Cabell versus Babbitt. In that case, the court found that the Department of the Interior had grossly mismanaged native trust funds and then failed to comply with prior court orders, actively misled the court, and even provided false information. This conduct implicated Treasury Secretary Robert Rubin and Interior Secretary Bruce Babbitt. The court issued an order to show cause why the government should not be held in contempt, and then held hearings to evaluate the evidence and hear testimony. And we talked about the standard of civil contempt in the video about Trump violating court orders. And in civil contempt, the aim is to typically force the contemner to
Is this supposed to be a video in there?
comply with the court's directives. In the Cabell case, the court first had to consider whether the orders were clear and reasonably specific, and the government tried to argue, just as Ensign did here, that there was too much ambiguity for the government to understand how to comply. The court must then be persuaded by clear and convincing evidence that the contemner actually failed to comply. And importantly, you don't have to prove that the contemner intended to disobey the order. The focus is simply on
Just
whether they
failed
failed
to
to meet
comply.
the terms of the order. And in Cabell, the government didn't produce the required records, failed to implement accounting standards, and then failed to communicate transparently and in good faith with the court. Which is why several times during the April 15th hearing, Judge Zennis warned the government that it needed to communicate with her in good faith. And in Cabell, both cabinet secretaries had to appear in court, and both were found in civil contempt. And the
I
remedies
think
included
that's
appointment
the big problem, is you just can't expect good faith from the other side at all.
of a special master to monitor compliance and independently review the agency's behavior, court supervision over native trusts, and a warning that future noncompliance would result in sanctions. So the bottom line here is that the Supreme Court approved most of what the judge ordered and cut it back based on what the court can and cannot do. The government is currently misrepresenting what the Supreme Court said and is so far
Misrepresenting. We got to use harsher language here. They're outright
refusing to do
lying.
what the court has required. Judge Zennis is moving forward, and she is pissed, and she's laying out the framework, like Judge Boasberg before her, to make life very difficult for the government. And we'll see who blinks first. But it's particularly interesting to
That's the thing, you don't have to do anything. I think he's going to go into his thing, so I think that's the end of it here, which is a good timing. But that's the real problem here. It's like, oh, who's going to blink first? Ask yourself this. If you're wondering, like, waiting for those dominoes, if the whole domino speech didn't get to you, now is the time to go back to the domino speech and think about it. So, as the dominoes fall, what is the thing that can stop them? Who is this the U.S. Marshals? Is that who you're hoping for? Is it some police force? Is it some deputized? Because I have seen some stuff where courts can deputize for specific things, just like this. They could deputize a force. Who is being deputized to do this? Who do you think is going to do it? And are you waiting for this thing? If you read the Supreme Court cases, so the dissenting opinions in Trump v. United States, the court makes it clear who the backstop is now. You can't count on that other domino. Whatever we're waiting for, the Supreme Court is going to keep doing their job. They're going to keep making their rulings. They're going to keep doing their things. Don't take that as business as usual. Things are going normal. They're not. They are not. And if you're waiting for that next institution or the one thing to stop it, or this one judge to be able to stop it, they are going to put pressure on this one judge and find something about her history or find something about her that makes them be able to villainize her to the cult. And then all of a sudden you will see, whether it's Mike Johnson taking away their funding, so you can't have these or flexing Congress's power to influence the courts in some way. If you see it done that way, whether it's pressure put on them, Trump has more than a few times put pressure directly on judges by releasing their information, by publicly announcing that they're doing something wrong, something like this. These things, these important things, are two good ones to remember. And then third, the physical safety of this judge. She is going up against a regime that has proven that they will disappear people. everybody thinks it can't be a judge. Everybody thinks it can't be them until it is. I think this is a really good transition to the next part, because if you ever ask why Comar Abrego Garcia's case is so important, it comes back to this poem. Martin Niemöller, so sorry if I'm butchering that, but this is the important one to remember when you wonder why I or other people are so willing to go all the way to the edge for this one case, for Kilmar's case. It's because first they came for the socialists, and I did not speak out because I was not a socialist. Then they came for the trade unionists, and I did not speak out because I was not a trade unionist. Then they came for the Jews, and I did not speak out because I was not a Jew. Then they came for me, and there was no one left to speak for me. You fight on the margin cases. You fight for the rights that are afforded to us to remain afforded to us, all of us who are supposed to be able to enjoy them, not just a certain few. And when they start taking them away from the people who truly deserve them, why wouldn't they take them away from you? I fight for other people who have their rights taken away, because not only, but one of the reasons being I want my rights respected as well. I want to fight for other people's rights, but understand that if you're only in it for yourself, it won't be too long. Just read this quote, read this poem, and understand it. It won't be too long before they come to you. You are not immune because you're white. You are not immune because you're whatever. If you've ever heard the real hard white nationalists, the people who go crazy into the neo-Nazis, all these people, if you hear them talk about it, none of them care about whiteness or anything like that. They want you to trace your origin, and they are the ones who decide it's important, and might makes right to them. If they are in power and they decide that blonde hair, blue eyes is it, that's it. You can have all your genes, you can be the most American person, but you have brown hair, and then that's it. That's why you don't let these people come to charge. That's why you fight on the margin. That's why you make sure that liberty in America, freedom, some type of freedom in the ability to protect your freedom is paramount. You have to make it part of America. Otherwise, America just falls apart. If you can be snatched up off the street without due process and then disappeared, anybody can, you can't. It has to stop right there at the beginning. You can't let it get to a point where you don't have enough allies left to stand up against this. And with that, we're going to end this portion